Justice, let's be in a layman's term or in the legal perspective, means fairness. Fairness means being treated in the way the law recommends or how you should be treated as a human being or as a person. And the question or issue of who deserves justice, everybody deserves justice.
Really?
Everybody deserves
Okay,
justice.
before we get there, for us to be talking about justice, it means there would have been a certain situation that would bring about a need for justice in the first place.
Yes.
Perhaps something, yeah. Can we have like an instance, something happening and then another person requesting or demanding for justice?
Well, we have to look at law. Law not as a subject or a topic, but as a set of rules that governs human activities, human behaviors. It is from that standpoint of knowing what law is that you will be able to determine at what point if there is an infraction or not. Then, in talking about fairness and who deserves it, if there is an infraction, the law is being administered based on the circumstances, based on the facts of every matter or of every case. So the law in itself doesn't have to be just. It may not be, but that is an agreed norm. That is a set standard. That is the set rules that we have agreed to govern us at the moment. So it may not necessarily be law as it ought to be, but as it
I
is.
really want to understand that it may not be law as it ought to be, but then what has become acceptable in that
Yes, the
environment?
society evolved over time, and we discovered that what is law now may not necessarily fit in to the evolution of the society in the future. That is to say that some of the laws that were made hitherto in the past may not conform with our behavior.
Okay, that's
the
why sometimes
establishment.
we have amendments, yeah?
Yes, that is
Like,
why amendment comes in. We can look at there are certain circumstances or scenarios that were not considered as at the time every piece of legislation was being made. But the need has arisen that there should be an amendment. Other opportunity, other avenues have been opened that we can see, oh, there is need for us to capture this that was not in it. We amend. So, but what is applicable is the law as it is, not as it ought to be. Until we get to where the law is, talking about how it ought to be will not be applicable. So that is the position of the law.
what is that thing that is not allowing it to be the way it should be? The
Yeah,
law.
you see, the human knowledge is limited. We are not God. There are foreseeable future and there is unforeseeable future. The future you see is the future you legislate for. The unforeseeable. I'll give you an example. At a point in Nigeria, we had the doctrine of necessity. It was not foreseeable as at the time the constitution was made that a president will die in office without ordinarily transmitting or making provision for the deputy or the vice to take over. And we called it as it were doctrine of necessity. The laws were as it were at that point, not it didn't cover that area.
Okay.
Yes, but the law, like nature, avoids vacuum. There must be something to fill it up. That is why that doctrine came in. So if you look at foreseeable future, every law as it is projecting into the foreseeable future of what should be. And you cannot legislate into the unforeseeable. No. The same way it does not take retroactive effect. If the law is effective from today, whatever that is wrong with a law that is effective today may not ordinarily be wrong as it were if the event occurred a minute before the legislation came in.
Okay.
Yes, those are the circumstances.
So, what are those things that, for instance, a judge or a court will put into consideration to enable them make a decision, give a verdict, and say, okay, this is the punishment for this person, this is the redress this person gets for in a situation. What are the things that a case perhaps must consist of, or Just something that, will help the judge to make a decision.
Every case is peculiar. Every case have its own facts. A judge is not a spirit, it's a human being. So every judge decides a case based on the material facts placed before him. Then that brings us back to fairness. See, fairness, like we talk justice, we talked about fairness. Fairness in this circumstance in judicial adjudication also means that you are given an opportunity to be heard. Opportunity either to present your case or opportunity to defend your case. To be heard and to defend. If you are given an opportunity in the circumstance of the matter, either to be heard, you brought a matter to court, the court gives you an opportunity to present your case. It is how you present your case that the judge or the court, as it were, will apply the set of laws that have been made without you in the mind. See, that was when I said a projection into the near future of what guides our behavior. So you look at it from that standpoint, that it is what you say, it is what you present. Now, the law is a scale. It's application of the law that have been made. No matter where you are coming from, there is a law guiding every transaction. So you are given an opportunity either to present your case or opportunity to defend your case. In either way, fairness. Fairness, in this case, that you are allowed to say it the best way you can. So the success of your matter is dependent in a court, is dependent on your presentation and the application of the relevant laws. So the judge, his work is simple. His work is simple because it is the set of facts that you present before the court.
So you could be innocent, but if you're unable to present your case the right way, you may not be found innocent.
You could be innocent in the true word sense of that word, innocent. But you are also given an opportunity to present your case, to contradict it. That is why if you look at the Constitution says you are innocent until proven guilty. So you are the one, the ball is in your court. After the prosecution has presented their case that you are guilty, you are on your own, empowered by law to come and state the other side. In law, we are taught the principle of audi autorem patem. That is fairness. Hear the other side. So you don't use what one person has said to decide a case. So you are given opportunity. If you fail, there's nothing the law can do to help you. But that you also failed as a defense to come and present your case does not mean that the person who presented his case as the prosecution will come out, will win. No, because he has to pass through the scale. The law will have to be applied to those facts he has brought to see and find out if the ingredients required have been established.
I'm very much interested in that, the ingredients. Yes. Now, you said the law has been prepared without any individual, per se, any peculiar individual situation in mind.
Yes.
Is the law just?
The law does not have to be just.
Why doesn't it have to be just?
Because it may not necessarily cover every scenario in life, foreseeable or unforeseeable. What makes it law is law as it is. It must not be just for it to be law. The law must not be just for it. See, if that will take us to schools of thought. If we want to do legal jurisprudence of what is law, there are various schools that define law, and this may not be the right forum to do that. But just a glance through, there is the one we call the positivist school of thought, headed by a professor called John Austin. He says law is a command of the uncommanded commander. So, to him, he sees law as a command. You must. So, if you are not in line, you are out of line. You also look at the realist school, the Scandinavian schools of thought. What do they tell you? Law is a prophecy of what the courts will do and nothing more pretentious. They see law as a prophecy. We talk about projection.
Okay.
Now, other ones say law is a set of rules that we have put together to govern our activities. So, from the standpoint,
these are actually interesting explanations.
From where you are, determines what you see. It's like the elephant. If you are by the side, you touch the ear. Oh, the elephant's body is so soft. If you touch wherever you are, that is law. But one thing central to or key to law is a set of rules that governs the activities of man. So it is the application of law. So law in itself don't have to be just. From where you are standing, it must not be just. Yeah, you see, one thing that we always emphasize in law is that law is not morality. There's no sentiment. Law is law. It doesn't have to suit you. It doesn't have to suit me. But it's just there. It's on a scale. If you bring your fact and put on it, if it tilts towards you, you have complied with it. If it does not tilt towards you, you have not complied with it.
Okay.
But it has nothing to do with your morality. It is devoid of sentiments. That is how it is.
Well, people have been to court for one case or the other, between an individual and another, or an individual and an organization, and they come out at the end of everything and they say there was no justice. What's usually, there's no situation in particular here now, except if, of course, maybe some of our callers would call in and give us their own experiences or scenarios. But then what usually happens when some people would go to court and come out and say, hey, they don't feel like justice was done?
A lot of things comes to play in the courtroom. We start from the presentation. One, our kind of system here requires that you prove, if in a criminal matter, beyond reasonable doubt. You see, sometimes you expect that you have done everything right. No, but there are rules governing every aspect of our legal life. If you fail to comply with these rules in presentation, you may not get to where you want to. Two, if you are supposed to also bring things that will support your matter, it's not enough that you have stated it, but the court, like I said earlier, the judge was not there when it happened. The judge will only have to decide based on the facts that are presented before him or her, before him. So from those facts, you begin to remove one. You discover that at the end, what you were thinking may not necessarily be the mind of the court, because some of the facts, some of the ingredients, some of the things you needed to bring as evidence were not brought to court. And the court is not Father Christmas. It will not give you what you did not bring. It will not give you what you did not ask for. So in those cases, people leave and feel,
they didn't get justice.
But in the eyes of the law, justice was served. I told you, the law doesn't have to be just for it to be law. Doesn't have to be just for it to be law. Then that is just one. If you look at the courtroom scenario, there are technicalities that are involved in law, whether we like it or not. Every law has an exception.
Okay.
Every law has an exception. For instance, if somebody comes to court and said was accused, and somebody who is an accomplice is being used as witness, we're supposed to be co-accused, but the law has a right to say, we will use you as a witness against this person. The law requires corroboration. The law requires that there must be somebody who will come and attest to the fact that what you are saying is the truth.
It's true.
If you don't bring that person, as good as the testimony you give will sound, as real as it may look, if you do not corroborate it, so there are conditions and exceptions to every law. If you do not give what the law requires to meet the threshold of proving a case, invariably there will not be judgment in your favor. In that case, you will go, you did everything. Justice was not served. So some people will be fair to stop at that point. Some will also, the judge was compromised. We are not saying, we are not into that anyway. But I tell you, more often than not, you don't get to see compromise. Most often, the fault is from we.
It's from the individual's inability to
Yes, what we
express.
have failed to do to help out. So when you, before a lawyer takes a matter to court, you look at it, you play the devil's advocate. What are those things that I am required to do in this matter? For instance, landlord and tenant cases. Did you serve on the tenant the statutory notices? If you don't serve, it's obvious that, oh, the tenant is owing you. But the law requires you to do some things, condition precedent, prior to bringing the matter to court.
Okay.
Yes. Which are the statutory, I will not go into that, but that's what we're talking. So I'm just giving you circumstances where we fail and we place it on law. Nobody wants to say, oh, I am wrong. Oh, it was my fault.
So even though the tenant was owing,
Yeah, of course.
and he had the right as the landlord to take the tenant to court, but there are a few things he is expected to do.
There are things you must do.
For instance, a few things.
Statutory notices.
Okay.
One, the law say they are condition precedent. If the tenant is deserving of a quick notice, you should have given him a quick notice.
Okay.
If failure to give a quick notice as at the time you were supposed to, then, and there's also what you call a fluxion of time. The tenancy relationship with the landlord must have been determined. So if you have also the tenancy ends or determines by a fluxion of time, then you have the owner's intention. You see, the law calls it notice of owner, not of landlord. Notice of owner's intention. That's one we generally call 7 days notice.
Okay.
If you don't give these notices, you may have a good case, but the conditions precedent, the conditions prior to you bringing a matter in court, a matter of such nature, have not been met. In that case, even when the tenant did not come, even when he did not enter appearance, it would have been, and opportunities have been given for the tenant to appear, he did not appear. You must prove your own case. You succeed on the strength of your own case, not on the weakness of the other parties. That is law.
All right, then. That's so much on what justice is. But who deserves justice now?
Everybody deserves justice. Everybody. You see, justice is not a one-way traffic. Justice to the party, justice to the court, and justice to the society. It's not a one-way traffic. So everybody deserves justice.
So 2 people are in court.
Yes.
What kind of at what point? I mean, at what point would this justice be given to, for instance, even someone who is guilty? I think the verdict at the end of the day, or even punishment for someone who is guilty, may not sound to that person like it's a form of justice. For the other person, it will be justice, yeah? But for the person who will be serving a jail term or any other punishment, he would not see that as...
The law or the court do not go out of their way to impose sanctions.
Okay.
They do not walk on the streets to bring people to court. Something happened. Let's look at the criminal procedure or the criminal situations, criminal cases. Something happened, a crime against the state, and you are brought to court. You are not saying the man who brought you to court is seeking justice, and to you, justice for the accused or the defendant will not be to go free alone. It will be that the matter is presented in the manner in which it should be presented. He should be given opportunity to be heard. If he's not available, if he doesn't have a lawyer, he should be told the implication why he should get a lawyer. If the state need to get him a lawyer, the state should get him a lawyer, and the state should make available to him or her the resources or the avenues for him to defend himself. If these things are done, you see, you discover there are also exceptions that he will plead. That is justice. So justice is not necessarily the outcome, but the process.
Okay.
You begin with the process that leads to the outcome, to the result, the end result. So at the end of the day, like I told, there may be more than one issues, 2, 3, 4 issues from one matter. The court may resolve one to in A's favor and the other in B's favor. In that case, you discover that, oh, this person was not entirely wrong, as we will say. Neither was this person entirely right in the same circumstance. So it is just that application, the application of the set of rules to each circumstance. Every matter, every situation is different. No two cases are the same. So once that is done, that is justice. What the court will do, or what the court will say, was the court fair in determination of the issues before it by applying the relevant laws, as it were. Yes, if that is done, that is justice to the courts. They have done justice in the way it should be done. The parties will also go home. You see, sometimes we betray our emotions. We know the court is fair, but we just want to say to please some people. In the other way, you will know the technicalities that are involved, that there were things you failed to plead. The court will not help you. The court is not Father Christmas. What you do not bring to court remains at home.
Wow.
So in a nutshell, everybody deserves justice. Everybody.
Okay. If you're just joining us, it's Probono Chambers on Human Rights Radio 101.1 FM. It's 10:32 right now. You get to call in and ask your questions. If you have more questions for Barrister Ochu Chukuma here, based on our topic, feel free to call in. If your questions are still legal matters, but then different areas, feel free to call in as well and ask your questions. The number to call is 08189 991011. That's 081 89991011. Let's hear your questions right here. Let's see. Hello.
Good morning.
Good morning. Welcome. What's your name?
My name is Spirit.
Okay, we're listening.
In the case whereby one get married, or maybe the marriage is being registered in the court, and they are to divorce. What will the both partners lose? Because I do hear that they will share the property or something like that. I really want to know about that.
Okay, wait first. You said in a case whereby a marriage is registered in the court and the couple wants to go for a divorce.
Yes.
Okay, what should they do?
Yes, and
what happens to the property?
The children, the property will be shared, or the children will be also shared.
Okay, so property and children, what happens to them? That's your
yes,
question.
what happens to them? Yes.
Okay.
All right, thank you. Well, marriage under the Act, dissolving a marriage under the Act, there are procedures that you need to take. It depends on the claims before the court and what you are bringing to the court. If it's the man, and it also depends on the ages of the children.
Okay.
But in all, what is paramount is the interest of the children. The court will consider the interest, the welfare of the children. One, it does not necessarily mean that everything will be divided. If the parties are not asking for the division of whatever properties they have, the court will not delve into it. For instance,
What if they are asking?
Yeah, if they are asking, the court will ordinarily look at a just way to determine it. What is the claim of the petitioner? The man who, or the woman, the party who goes to court is the petitioner.
Okay.
And the defendant, or the person who responds, is the respondent. If the petitioner says, I have this, I have that, or we had this together. And we don't want to. Yes, and you state in your own petition how you want it to be done. If the other party agrees, it becomes what you have agreed. But if you don't agree, the court will look at it. How will the court look at it? Were those properties jointly owned? Were they acquired while you were married? If they were, yes, the court will divide it in accordance with what you will agree. But another naughty area is usually the custody of the children. custody of the children, who has this child, the court is always inclined to giving a woman custody of children where they are very, very young.
Okay.
Yes. And it also depends on why you are going to court to seek divorce or dissolution of the marriage. What are you accusing the other party? What are the scenarios? What are the circumstances? You look at these issues.
Okay.
Then, even in granting custody to a party to matrimonial cause or a divorce proceeding, the interests of the children are paramount. Their age is a determining factor. Their sex is a determining factor. You are a man, you want to, if the children are girls and they are of tender age, the law will always presume in favor of the mother, assuming it's the man that is the petitioner, for the mother to keep them. If they are also boys, the law presumes that a boy who is up to 7 years old will be better off in the hand of the father. So it is neither here nor there.
Okay.
But you must, as the petitioner who wants to take custody of the children, state in clear and unequivocal terms what you have provided for the welfare of the children in the absence of the other party, probably their mother. What are the arrangements you have made for their education? What are the arrangements you have put in place for their health, for their maintenance? And in other cases, what is the arrangement you have put in place for your wife, as it were, the party you now seek to go your different ways? What have you put in place in form of maintenance?
Okay.
If the children are also going to be given, so it is neither here nor there. But in most cases, the courts have a duty, in some cases, to bring the children. If they are of age, if they are from 8, 9, 10 and above, you have a duty to bring the children, to ask them
who they would rather be with.
Yes.
Oh.
Because, you see, in a matrimonial matter, it is the interest of where in a matrimonial causes, where custody is an issue, the court has a duty to find out the allegations, counter allegations, are they true? And in all, depending on the age of the children, the court calls the children. Who do you want to be with? Sometimes too, another scenario, you discover that either one of the parties are no longer in the home, in the matrimonial home. Either the woman has moved out, and as at the time she left, the children started staying with their father. The court considers everything that would have happened from the date issues arose. But paramount is the interest of the children. Okay. Even if the man say, I want to stay with the children, and the children say, no, we don't want to stay with you,
the court will listen to what the children are saying.
And they also find out what are the reasons why you don't want to. Are there issues of cruelty? Do you beat them?
Okay.
Do you maltreat them? Do you do to them what ordinarily should not be done?
I'm sure that answers the caller there.
Yes.
All right, well, let's hear who is here. Hello? Hello? Okay. What happened to that call there? Please call back 08189991011. Let's hear you right now. Hello?
Hello?
Good morning.
Good morning.
Welcome. What's your name?
Okay, my name is Esther from Karimo.
Okay, go ahead, Esther, please.
I have a question.
You need to turn off your radio, please. Please turn off your radio.
Kobo did a court registry, but they did not do their traditional marriage. Then along the line, the man now went to marry another woman. He paid a dowry, even they wedded in the church. So my question is this. Due to the traditional marriage that has not been done, is the marriage still legal? Then another question I have, if the marriage is legal, can the woman sue the man to court or marry another woman, and if the woman now decides to leave the marriage, can she marry to another man without suing the man for divorce? So these are my questions.
Well, thank you, Esther. I hope you can hear us.
Yes.
All right. If I got your scenarios right, the man and the woman was married first in the registry. That's in the court, as it were, registry. After a while, the man, without
dissolving this
wedding, and without dissolving the first marriage, goes ahead to do traditional wedding and goes to church to marry. Let me do a quick distinction about marriage under the Act and church marriage. See, marriage under the Act is the one the law recognizes. The one we do in the church is celebration of marriage. So it is blessing. But what we have most often done now is that the churches are registered with the registry that they can issue you the license. And if you also watch, most churches will tell you to go and do to go to the registry before coming back to them, whichever way. That once you are married under the Act, the law precludes you from getting married to another person under the Act. See, I did not say from getting married under any circumstance. Precludes you from getting married to another person under the Act. If you do that, that is an offense called bigamy. Say he who marries and marries again commits the offense called bigamy. But we also look at our traditional circumstances where some custom, some religion permits you to marry more than one wife. So there is no hard and fast rule for it. It does not also preclude the aggrieved party, as it were now, seeking redress in court, particularly the one that was married in the registry. That's a legal marriage. It has not been dissolved. You have not been dissolved. And for you to go your separate way, you must seek for divorce. Because or judicial separation, whichever one that is most convenient or applicable, as it were. The man has gone ahead to marry. Marriage under the law is recognized as much as marriage under traditional law and custom.
Okay, we don't have so much time at this point. Now, the question for she's asking now is what can she do? I mean, that's thinking if she is the one that did only the registry marriage.
Yes.
Now, in this instance, she's married to this person, in the court, but then he goes ahead to get married to another person.
She can seek redress in court. It does not matter that you did not do traditional wedding.
Okay, but she can't just go ahead now and marry another person herself.
No, she cannot marry another person in the circumstance.
So she'll have to take him to court first.
You have to dissolve that marriage. Having been married under the Act, you cannot just go and marry under the Act again. You must dissolve that marriage. You must dissolve that one first before you go ahead to marry another man or a woman.
All right, then. Yes. So I'm sure that answers her question. I don't know if we can pick any other call at this point, but let's see if we can have a quick one. Hello? Okay, I lost that one there.
Yeah.
Okay, let's see. Hello?
Yeah, good morning.
Good morning. Welcome. What's your name?
I'm Ruth.
Okay, my name's Go ahead.
Am I speaking to Human Rights?
Yes, this is Human Rights Radio.
All right. I just want to make some inquiry similar to what the previous caller just called and inquired for.
Okay.
Yeah, what of it in a situation by you are in a relationship with a man and the man paid the bad price, and then on the way you people now got some issues, and now he decided to say, that's the man now decided to say, okay, he's no more interested in the marriage again. You understand? So, and we don't need the bad price again. So, that now lasted for about 4 years. After that, he went ahead and married another different woman. Is it possible for the woman to return the bride price that he has paid, Oh, and he, initially he said he don't need it again.
Okay. He's not interested in it, but then you're asking, should this person return the bride price?
Yes. What if the woman now got another different person that wants to marry her? Is it possible to pay, or is she free to marry another person?
Okay.
Okay, Ruth, if we understood your question very well, yes, I will just answer it directly. Yes, you are free. You are free
to take that one on top of the other one.
Yes. You see, the custom has a way of replaying or repeating itself. If the man says he doesn't want, and you want to return it, you can go ahead and return it. You see, he did not marry you in isolation. There were some traditional, right? But if the man says he doesn't want, it's okay, and he has made that known, he will not come back tomorrow
and say, yeah.
Yes. But if you feel you need to return the dowry, please do so, and safely. It doesn't stop the other man it doesn't stop you from getting married to another person, because in the eyes of the custom, you are not married, and you cannot force an unwilling horse. You can only take a horse to the river.
All right, Ruth, thank you so much for calling. Okay, well then that should be the size of our program for this morning, though. A little more on let's just put it like your advice to people. I mean, especially based on our topic for today, yes. The area where you talked about that sometimes it is because we fail to express ourselves properly, and that's how at the end of the day sometimes it may look like we did not exactly get justice.
Yes, what I would always advise is get the services of a lawyer.
Okay.
When you have an issue. You see, not only when you have, you see, most often in our climb is when there is a problem, it's almost a near emergency that we seek the help of a lawyer. There is a difference a lawyer makes in every situation. If a lawyer is going into a transaction with you, he gathers his facts from day one and put them straight, devoid of sentiments. He sees litigation at the end of it in the event that there is disagreement. In that case, it will not be difficult for him. But in our business environment today, what we see is, or what we hear, I have problem with him. We entered into $1 million agreement. There was no contract. We did it. There was nothing written. It is your word against my word. It is as much as you can remember. So, in order to help us, get the service a lawyer. I know people are afraid to pay legal services.
That's it. The average person feels it's very expensive, so the best thing is try and see what you can do on your own.
In the long run, you see how cheap it becomes. Because you may discover that you have lost 1 million. Probably what you would have paid the lawyer is a percentage, a 10% or less of the 1 million, depends on your agreement. You may discover.
Okay.
If you go to a doctor, you pay consultation fee. Most lawyers will not even take consultation fee. They want to talk with you. They want to guide you. But sometimes we feel another thing, that we know better. Yeah, people feel, I know, I have had experience from this person. It's not the same. There is why the lawyer is called a lawyer.
Okay.
So he will do that.
So your advice is to get a lawyer so that you can get the right advice.
In every transaction, retain a lawyer. Retain a lawyer. As you hear people say, I have a family doctor. They don't do anything for you. When you have issue, you know somebody to talk to. You register there. Sometimes, the family card. 80% and above of Nigerians don't have a lawyer. It's when they have issue. They come to this. Do you know a lawyer? They have never spoken to a lawyer about an issue.
All
that
right.
is the problem.
Okay, then thank you very much. That has been Barrister Ochu Chukwuma on Probono Chambers today. We appreciate your presence on the program today.
Thank you.
And many thanks to those who called in as well with your questions. I hope we all did benefit from his explanation today on the program. Thank you. We'll make a return tomorrow, God willing, but do stay with us on Human Rights Radio 101.1 FM Abuja. My name is Ruth Usman, and I'll see you tomorrow.